Hello everybody, this is your instructor for the class of Labor Relations in the Public Sector, Mariana O'Brien. This video intends to assist you and guide you through the process of exercise number 2. The objective of this exercise is to apply all the literature we have read throughout Module 3 in a specific example of arbitration and arbitration appeal. Module 3, Grievance and Conflict Resolution, require us to read all these 5 chapters plus the additional material. Please pay particular attention to the additional material because it provides the administrative procedure established by law to present any case of grievance. As we remember, a grievance is a dispute excluding a dismissal or an involuntary separation due to a reduction in force between an employee and management of the employee's agency, which involve the interpretation or application of policies, rules, regulations, and/or statutes which have been adopted by an agency, governor's executive order, or the state legislature to cover personal practices and/or working conditions. In the previous lectures, we have seen that there are several mediation programs before the complaint escalates, which assist disputing parties in reaching a mutually acceptable resolution to issues and concerns raised by the parties. However, employees who voluntarily choose to participate in the mediation programs shall not forfeit their right to present a grievance or appeal in accordance to the state legislation. The State of Wyoming Personnel Rules, Chapter 12, establishes the procedure to follow by permanent employees in the public sector. It provides definition of who are entitled, the employees' representation, their parties, the grievance committee, and the personal appeal hearing. This figure intends to explain the process of arbitration. I have color-coded the parties for easier interpretation. Employees are represented by blue boxes. The agency or management is represented by yellow boxes, while the neutral third parties are represented by green boxes. Once an event happens, the employee has 10 days to complain to his or her supervisor. Management employee shall hold a conference with the employee within 10 days of the complaint. The supervisor has 10 days to submit a written decision to the complainer after the conference. If the written decision is not satisfactory for the employee, he or she can submit a grievance in writing to the agency head within 10 days of the written notice. A conference between the agency head or his/her designee and the appropriate management employee. They must send a written decision within 10 days of that conference. If that written decision is not satisfactory, the employee then may, within 10 days of the date of the decision, request the Human Resource Administrator to establish a grievance committee to hear the matter. Within 10 days, the State Human Resource Administrator and his/her designee shall notify the head of the agency with which the employee has the dispute and request the nomination of one grievance committee member. The agency head shall notify the State Human Resource Administrator of his/her designee of the nomination within 10 days. Within 10 days, the State Human Resource Administrator shall notify the 2 nominees that they are to serve as grievance committee members and that they shall, within 15 days of the receipt of such notice, form the committee by selecting a 3rd member. Once the grievance committee is formed, they have 45 days of the formation of the grievance committee. The committee shall schedule and hold hearings or render decision without a hearing based solely on the written record. These 45 days might be extended by mutual agreement of both parties. Within 15 days following conclusion of the hearing, the grievance committee shall prepare a written summary statement of the evidence and its findings, decisions, and recommendations. I have posted examples of decisions in the exercise webpage in WIO courses. The arbitration appeal process. Within 20 days after the date the decision of the grievance committee, the employee may file a petition for a personal appeal hearing with the State Human Resources Administration. At this point, the employee is referred to as the petitioner. Within 5 days, the Human Resources Administrator or designee shall provide a copy to the Attorney General, the employee's agency, and the employee or his or her representative. Within 20 days of the petition for a personal appeal hearing, the respondent shall file a written response or challenge the motion because of timeliness. Within 25 days of the filing of the petition for a personal appeal hearing, the agency shall file with the State Human Resource Administrator a designation of presiding officer. A designation of presiding officer on the appropriate form designated by the State Human Resources Administrator. If the agency files a completed and signed designation of presiding officer, naming a presiding officer upon which the employee and the agency agree, the State Human Resources Administrator shall assign the matter to the named presiding officer within 20 days of the date the petition for personal appeal hearing was filed. If the parties are unable to agree upon a presiding officer, the State Human Resources Administrator shall assign the matter to the Office of Administrative Hearings within 35 days of the date the petition for personal appeal hearing was filed. Within 10 days, the Office of Administrative Proceedings shall notify the parties of the hearing officer assigned to hear the appeal. This qualification of an Office of Administrative Hearing Officer shall be filed with the Office of Administrative Hearings within 10 days of the issuance of the Office Administrative Hearing docketing notice. Once the presiding officer have been assigned, he or she shall open a hearing and render a decision within 30 days of the close of evidence and submit a written decision to the State Human Resources Administrator, who shall forward copies to both parties. Now that we have seen both processes, the arbitration process and the arbitration appeal process, let's see the details of exercise number 2. Exercise 2. Same as exercise 1, this assignment has 2 parts. One, the theoretical part, which consists in a well-written paper explaining the process of arbitration and the appeal process as well. I have posted additional forms to help you in this exercise. These forms are from the Federal Labor Relations Authority. They are not mandatory. However, they can be used as guidelines to see what information is needed to be provided in order to proceed with these administrative issues. The practical section entails the application of Modules 3 concept in a real-life example. Please simulate a labor dispute between firefighter unions and a city, town, county in Wyoming. Be consistent throughout the exercise, through the arbitration procedure and through the appeal procedure. Identify who are the parties. The firefighter union would be the labor, while the city, town, or county would be the management side. And what agency are in the third party or neutral for the arbitration procedure, such as the State Human Resources Administrator. In selecting a panel of arbitration, I'm also attaching a form that you can use for this purpose. Remember that you have to select one arbitrator for the union side, one arbitrator for the management side, and together select a third member. Please explain the process of arbitration step by step. Next, draft a decision. In this link, you can find some examples of authority decisions that you can use to design the decision of the final arbitration. Next, the second procedure starts. Appeal the arbitration resolution. If you go to this website, you can see a checklist provided by the Federal Labor Relations Authority in regards all the information needed for this appeal. I have also added another form in a Word format to help you to file your appeal.